Hello and welcome to this segment of Queens to Cleveland. That's our Estate Planning Lawcast. Hi, I'm Andrew Jaloza from the Estate Planning Law Group here in Glendale, New York, and I'm here with my colleague.
Matt Deliberato. Welcome, Andrew. How are you?
I am great. Matt, what state and city are you in?
Cleveland, Ohio. Can't beat
All
it. It's a
right.
nice, dreary, rainy day. We don't get much sun over this way. I don't know about you.
Well, we have sun, but I understand that we're going to be getting some precipitation today. And
Uh,
today, what will we be discussing? We'll talk about what probate is and why you may want to avoid it.
yes, exactly. Well, and we should start with what is probate, right? Probate is the legal process of administering an estate after someone dies. It involves determining the validity of a person's will, identifying and inventorying their property, paying any outstanding debts and taxes, and distributing the remaining assets to the beneficiaries. That all sounds really good and easy, but as we know, probate's what I call an RPIA, a royal pain in the you fill in the blank.
It certainly is, Matt. It certainly is, especially because there's no control. You lose all the control. You turn over your control to the state. They tell you what you have to do, when you have to do it, who has to do it, and don't tell you why you have to do it all the time. But there is a bunch of different things to do. So we'll go into that. And what's the difference between I hear probate administration. What's the difference of those things?
Well, probate and estate administration are basically the same thing, right? We have to go to the court and get all this. I always say like the 90 steps of probate you don't want me to talk to you about, right? It's extensive, it takes a long time, and it costs a lot of money. But
Yeah.
why do people want to avoid probate, Andrew?
Well, we want to avoid it because of just what you said. I mean, especially the difference between probating a will versus going through an administration procedure. Both of those take place in the courthouse. Where do we go to fight in our world, right? There's no more
Yes,
gladiator pits. We
right.
don't go out and pull out the swords and duel or go 10 paces and turn anymore. So where do we
That's
go to
right. That's
fight?
right. We
Go
go
to
to
court,
court.
right?
We love it.
And probate takes place in surrogate's court, right? And
Well,
surrogate's court, go ahead.
I was going to say, and let us be clear that Andrew and I both don't want you to go through probate. We don't want this to happen to you.
Right. Although we do make more money when you do go through
Well,
probate.
that's true. That's true. So we can just sit back. In fact, I just had a client, Andrew. They came in, they have 20 plus properties, rentals, etc., probably worth about 3 mil. And he came in, we got everything set up. We were going to do a trust. 3 days later, they called, they found him dead in his home. And so now we have $3 million going through probate. And the family came in and said, well, doesn't it mean anything that my dad already expressed his wishes and met with you? I'm like, absolutely not. There's nothing in writing. We've got nothing to go on. So it's it's going to cost them an arm and a leg. No pun intended, right?
Right. And so you said that he was intending on doing a trust, but he didn't even have a will at this point. Is that correct?
Right, right. Doesn't even have
Wow.
a will. Yeah, yeah.
So that's what we were talking about one moment ago. So administration is a process that when you die intestate, that means without a will. And what that means is all the rules that we talked about and all those court rules and that procedure in court is all going to happen. In addition to that happening, the state is going to tell you who gets your property. So if
Yes.
you have any desire to give your money or property to people who are not on your family tree, well, they're getting cut out. And if they're not close enough as far as relatives here in New York, because administration goes out to second cousins. So if you have a third cousin and you have that $3 million of property, your cousin's not going to get it. It's going to go to the state. It's going to call what Ishit. It's going to go to the state, right?
Well, that's right. And in Ohio, we go a little further than New York does in our family tree. And I remember a case I had once. We had a gentleman who passed away, and by the time he was done, we had to go up to the maternal and paternal grandparents to figure out the family tree. Well, his grandfather on his, I think it was mother's side, had like 10 children, His wife died. He remarries and has like 7 more. So we have so many people in this family tree. There were some people that got $23.10 as their as
Wow.
their inheritance. Yeah. So it's
Right.
definitely something you want to avoid. It's definitely something you don't want to go through.
Right.
Um, and what happens during probate?
Well, what happens during probate is the court tells you what documents you have to file. If you have a will, then the executor has to file a petition, or someone has to agree to be try to be appointed as the administrator in probate. And either one, you have to have documents signed by all different people. Every other person who has the same rights as the person who's applying will have to sign some papers. What happens in my world is I've seen it before. People don't want to sign papers sometimes because maybe they're the oldest and they don't like the fact that the youngest got appointed to be the executor or the administrator. And the court has a way of, the court has a rule about who will be the administrator and what order. So what you have to
Yes.
get is what's called a waiver and a consent in order to move forward. Do they always sign that, Matt? I know that people walk in the office saying, "Ah, my kids always get along," and everybody agrees on everything. What do you find?
Oh yeah, they agree 100% of the time. Not. They do not. There is always some issue. There's always something going on. And you know what I find, Andrew? It's mostly what's happened in their childhood. It's a sibling that, mom treated her better than me, and, I'm going to really screw it to her. It's just never seems to amaze me how much um, trouble we get into with, well, any estate administration, right?
Yeah, absolutely, absolutely. And so the person who's appointed doesn't really have any power to do anything
No, no.
until they get these letters from the court which says you are hereby authorized. And
The
those
golden
letters may
ticket.
be their golden ticket, which may be restricted, right? There are often times where the surrogate decides that you have to file a big bond.
Yep.
Usually in an administration, you have to file a big bond, so it's more expensive for the estate. And in addition, sometimes, they restrict it because they want to make sure that the administrator or the executor is not going to go and abscond, despite the fact that you're even having a bond. You
Well,
see that quite often when there's real estate involved.
absolutely. And in Ohio, they're erring towards just posting a bond, even if the will says no bond required, because it's usually that the executor can't fulfill the duties, so someone else has to be appointed, or they have someone out of state, or whatever the reason is, that bond, or basically an insurance policy that you won't run away with the money, is um, imperative to these courts. And it does. It costs you a good chunk of change just to get a bond. And you hope people are bondable. I mean, I have one guy come in, he says, "Well, I have a felony." I said, "Well, you're not bondable. You can't get a bond." So, all these things have to be thought of beforehand. And speaking of beforehand is, I guess we should talk about, okay, how do we get out of probate? How do we avoid it? And I think there's several ways to do that, but and Drew, maybe you can tell me a little more about what can we do to avoid probate?
Well, we could do some things that make a lot of sense and things that may not make as much sense, especially if we have the hindsight as a 2020, right? So we can transfer property to some of our beneficiaries during our lifetime. That is one way of
I'm
avoiding.
putting the
Oh,
brakes
look,
on.
he put my brakes on.
I'm putting the brakes on. Don't do it, right? We'll talk
Right,
about why not, but go ahead.
right. Yeah,
Sorry.
we often say that you should never transfer your property to your children while you're alive. And the real reason for that is because they have their own lives, and the things that happen in their lives may now affect your property.
Right,
Your child hits somebody with their car and kills them. Now you have a judgment against your house. Your child has debts to somebody. They get a judgment against your child. They filed a judgment. It's now listed against your property. Or you
right.
may find yourself living in your daughter-in-law's house because now your son passes away and leaves no will or leaves a will saying everything goes to his wife. Now you're living in their house. And how many
Yeah.
times have you seen a person get thrown out of their own house or restricted in their own house?
Oh, it happens all the time. In fact, I remember, just to bring up another issue, as we talk about transfer on death affidavits for a house, which, you think, wow, that sounds great. We avoid probate and it goes to the people who I appoint. Well, we did thousands of these deeds when they came out. Now I won't do them. And that's only because I had one case, we had 6 kids. So they leave the house to 6 kids. Can you imagine 6 people having to sign off on closing paperwork on a house? But in Ohio, we also have dower rights. I don't know if you have those in New York, but we have dower rights. So the spouse has to sign off on the sale of a property that's in their name. Well, in this case, we had one going through a divorce, and that gentleman said, I'm not signing anything. And so talk about the proverbial, right? Who's going to sign and when and how.
Right.
It took him 3 years to sell that house.
The screeching halt, right?
Yeah.
Everything came down to a screeching halt.
Yeah.
Yeah, and that's what happens when you transfer property during lifetime. There are also tax consequences if you don't do
Yes.
it properly. So there's a
Correct.
bunch of good reasons not to transfer property during your lifetime. The other way is to appoint beneficiaries, right? You make
Yeah.
people the beneficiaries of your property. In New York, we don't have a transfer on death deed. We
Ah,
probably had it somewhere along the line, but it's been a long time. They haven't had that for a very long time, and so we don't do transfer on death deeds. But transfer other things on death may be a good idea, maybe not. But it depends upon what's the circumstances that person's going through. When you die and leave it to a beneficiary that's died, it's back in your estate. You're going through probate.
yeah. Yeah. Or I say all the time, you have 3 kids and one of them passes, the other 2 get the money, the kids of the deceased child get nothing, right? It's something can happen bad in all those situations. And we always say, you love your kids way too much to give them money. You love them enough to give them a trust. And
Yeah.
so that is ultimately the way to avoid probate, isn't it? I mean, that is really what we're talking about is creating trust.
Well, that is definitely one of the best ways to do it. And the best way
Yeah.
to do it is especially if you have some rules that you want to create over what happens once you've given it to them, right? We have all
Yes,
different
yes,
scenarios that, creating a trust after death, even a testamentary trust, because a good thing is that we can do wills and they create trust, but trusts create trusts as well. And
yes.
this way you can create future plans because if you give it outright to somebody, it goes in their name to do whatever they want. And then how you want that money to be spent or protecting them against some of the things that may be going on in their lives becomes impossible once it goes directly to them.
Right, whether it be a divorce, they owe someone money, they get sued, they're in a nursing home, they're on governmental benefits, whatever the reason may be, it's always better to leave a trust. A trust doesn't die, a trust doesn't become disabled. And it's all about control at that point. For example, let's say I have a child that's addicted to drugs. I can't give them control over their own trust. I have to have someone else control it for them. And that's really kind of the meat and bones. I know I'm getting away a little bit from probate, but that's really the meat and bones of what we do and how our plans have been so successful for the families that we serve.
True that. And also, I mean, when you create the trust, even in a will, you get the same benefit because what if you have someone who has special needs? Like you said,
Yes,
it affects their
yes,
benefits. You need to have some planning especially if you have special needs children. And also,
yes,
the other thing about trust versus using a will is that when you go through probate, this is a public process, which is
yes,
the thing that I don't understand is how in this modern world where now everything is on the court's website and all
yes.
the information is there, does it make any sense given the fact of how rampant, like identity theft and things like that are?
Oh, absolutely. Yeah. I think that, we look at examples, Michael Jackson, Prince, Elvis, these are people who didn't have wills. We can watch how much comes into their estate and how much goes out of their estate. It's amazing to see
Yeah,
other people's money, and that's very doable. And, we just did a workshop, by the way, for our maintenance clients that talked about senior spam, like attacks against seniors, right? Like spamming or
right.
any of those things. And, it's interesting because you never expect it, but it's always happening to you. And this is something that in probate you can make sure doesn't happen to you. And that's what we're here for and to make that happen.
No doubt
Because
about that.
probate's not always necessary, right?
No,
I
it's
mean,
not necessary if you do something to make it not necessary, right?
yeah,
But
well,
if you don't do anything,
yeah,
probate is the plan, right? So
yeah,
one thing that people may not understand is that if you have a plan that you've created, now you have a plan that does pretty much what you want. If you
right,
don't do anything, don't worry, there is a plan. You have
right,
the laws and rules of your state, which says what happens, including who gets your money. It also says who gets to see whatever is going on in your life,
yeah,
because those are the state rules.
yeah,
And how do you avoid that? You create your own. You create your own
yes,
rules and
your
take
own rules.
control of the situation. Is probate always necessary?
No. No. In fact, I would tell you that in Ohio, and I'm anxious to hear what New York does, but we have what we call a release of assets. It's a small estate administration. And so that is done, anything under $35,000 can be done in Ohio, pretty simple. It's not a lot of process and headache. And then further, anything $1,000 or less, the court will give us a letter, and we don't even need probate. We just pay, I think, $50 for this letter, and they say, yes, go ahead and release it. Anything above the $35,000 is a full administration, which means the whole shebang. You get probate jammed down your throat, whether you like it or not. Is that the same in New York, or is it a little different?
It's a little bit different. Our
Is it?
limit is 50,000,
Oh,
and
nice.
there is a do-it-yourself process for estates 50,000 and under that is relatively easy to navigate. And there are a lot of there's a lot of things that go around probate because banks and other entities agree that affidavits, attesting that the basically it's the only asset or it's a small amount of assets will often be will often accomplish what you need to do in passing on some of these low value estates to whom it's
Yeah.
supposed to get.
Well, and we should
So
say this is a good testament that the rules around probate vary by state, so it's important to consult with an attorney. And,
absolutely, and
that's
especially how many people come into your office and they say, something, I got my will done. I avoid probate now, right?
yes, yes.
Mm.
All wills go through probate, right?
Right.
We talked about this on our last one, but certainly we need to remember that a will is governed by probate, and the only way to avoid it is either joint ownership, beneficiary ownership, or a trust.
Exactly. Exactly. You hear many people think that they're avoiding it, but actually, what I've heard probate likened to the fact that it's something that it's a ticket to go to probate that you pay for on behalf of your creditors. Because
Yes.
once you're in the probate system, there is a publication requirement, and you must give creditors a chance to come in and make claims against the estate. So you talked about trust. Is that the same way it works in Ohio for you, that you have to give notification to potential creditors?
Yes, we do. In fact, well, we don't give notification. We don't have to publicize. What happens is once it's open, they do put it in the legal news here, but the creditors have 6 months to make a claim. And so after 6 months, they're forever barred. If they don't make a claim within 6 months, it's gone. And so, a lot of our estates here, believe it or not, we'll wait 6 months before we open them. Because if they haven't opened a probate, then they're out of the box.
Got you.
And similarly is I can't even say that word today. See, it's Monday. I knew it was something's wrong with me. Um, but um, I lost my train of thought. See, I can't speak a word and I can't
So what we have,
help me
what we
out.
have
Help
in
me, bail me out.
what we have in New York concerning creditors' rights is
Yes.
that, yeah, that within 7 months of receipt of the letters of letters testamentary or letters of administration, where the court authorizes the personal representative to begin dealing with the estate, a creditor must make claims within 7 months of that date.
Uh,
However, if the personal representative has distributed out all of the assets, when a creditor makes a timely claim, they
mhm,
themselves may be responsible for paying for those debts. So there's personal liability that would come upon a person who does that. The good news in New York is that we don't have to notify creditors that a trust has been formed, or that there is property in trust. If they make a timely claim, if there is a probate, if you've put all your property into a trust and you've named beneficiaries and you have co-owners for your property and you're not going through probate, it's very unlikely that the creditors are going to be able to come and get back that money that was left in the trust.
Yeah, in fact, in Ohio, creditors are only subject to what's in probate. Anything outside of probate, they cannot touch.
Yep.
Yeah. Yeah.
So yeah, so I mean, probate seems to be a pretty time-consuming, expensive public process, and there are many ways, some of them good, some of them bad. Probate can be avoided, but as
Yes.
as Matt said, this is sometimes complicated, and there are several ways to avoid probate, including creating a trust. And so, but it's important to consult with an attorney or some, to get some knowledge, to understand what your pros and cons are of whatever course of action you think is best for you. It's good to check in and make sure that, it's legally sound and is going to accomplish what it is that you want.
Oh, it's so important. In fact, I just talked to that client I was telling you about with the $3 million in property, and the daughter got, an estimate of what our fee would be, and she said, "Well, don't you have any mercy?" I said, "Mercy, mercy is the court determines the fee in Ohio. So we don't set that fee. We are told what's reasonable, and here's what's reasonable." And she decided, "I'm going to do this all on my own." Well, we'll be getting a call in a month or two, because it is
Yes,
just amazed that you cannot manage yourself. It just
uh,
isn't.
that definitely happens to us as well. So,
Interestingly enough, I'm sorry, real quick, and one
no,
other
go.
thing I thought about is in probate here, there is one county that'll allow people to do it on their own. Every other county, they will tell you, go get an attorney. Does that seem to happen where you are?
I think there are plenty of people who try to do it on your own here. The
Yeah.
clerks, I guess, I'll put it this way, the clerks are more helpful to the people who are coming in to do it on their own than they
Yes.
are to us and our staff, because they think we should know what we're doing. And,
Right.
there they help them. And
Right.
they should help people who want to do it by
Sure.
themselves.
Sure.
Pro se, going in, doing it yourself is something that, most people go and try it and then they come hire us, or after having gone and tried, they come hire us because they realize it's really a very frustrating and complicated situation that
Yes.
could be avoided. Sometimes people get lucky and it works out just fine. But if you want a private process and you want it to make sure that things go in the way you want to, and you want to create a scenario where you can have some say over what happens in the future, and make sure you sometimes protect your loved ones from themselves or the people who are coming after them and trying to get their stuff. You have to do some planning. It will not just happen if you let it go to the state rules and the rules of giving things away. None of that is possible. So probate is a good thing to avoid, and I think that next time we'll be talking about trusts.
Wonderful. I can't wait. That's so exciting. Trusts are one of my
Yeah,
favorite topics. And thank you, everybody. This is hopefully a good use of your time. We're excited to bring this lawcast to you, and we will see you soon talking about trusts.
yep.
Andrew, thank you so much.
And thank you, Matt. And you can reach me at Andrew Jaloza at the Estate Planning and Elder Law Group, Glendale, New York, at info@epelg.com.
And
And
you
look
can
forward to hearing you.
yes, and you can reach me at info@icanprotect.com or visit our website at icanprotect.com. Great talking to you all, and thanks, Andrew. Have a great day.
Matt, you too. Thank you, everybody. See you in episode 5. Trust's coming.